she doing? What is she doing? Who does she think she is?
I don't live here.
And give a lot of feedback.
Well, good. Hang on. What's wrong with the, you live in Toledo. You don't live in Juneau, Alaska. Give me a break.
I lived in
Ma'am, I would quit while I'm behind right now unless you got a lot of money with you right now. Okay? I don't really want to hear it. I don't want to hear it. Tell it to some other judge in some other city in some other state. 22A, B, and 22R512824A. And also 22R512824B. Who's her lawyer, John?
Oh, I'm sure. Thanks a lot. I'll assume I have no one.
I need him.
Yeah. Well, there it is.
All right, I called McBain here. I have 22F237322A, which is a driveway license not valid. 22F237322B, which is a civil infraction, improper lights. 22R512824B, which is a failure to pay on a limited access. 22R512824A, which has not been adjudicated. That's a no ops. I hope she has a lot of money. She's been playing games with us. Your appearance? Name, ma'am?
McNally Bay.
All right, so what are we going to do here? She doesn't want to show up, so she's probably going to have a high cash bond, if nothing else. On the no valid license, does she stand mute and wait for a reading? She's only missed about 4 or 5 times on this. And then somebody will be a wise guy and say, oh, you sent somebody to jail on a drive while like, well, I don't know what else to do short of tackling them and bringing them in here. What if she's got others, limited access, $306. Does she stand mute? This is on the limited access from 2022.
I think we got the big traveling possibly tomorrow, so you'll do it upstairs.
Boy, you don't have much respect for courts, huh?
No, I actually
Somewhere between 0 and negative 2,852, it looks like to me. I mean, Judge Hessen's been overly kind. Okay, shake your head. Judge Hessen's been overly kind with you.
Yes, I
Does she
appreciate
stand mute
that.
and wait for a reading on the other one?
Yes.
A guilty plea on that. She has flat rock in front of Judge Hessen, failure to pay. Does she stand mute and wait for a reading on that?
Yes.
Wow. If I had a nickel for every time you missed a court date, I could. She doing? What is she doing? Who does she think she is?
I don't live here.
And give a lot of feedback.
Well, good. Hang on. What's wrong with the, you live in Toledo. You don't live in Juneau, Alaska. Give me a break.
I lived in
Ma'am, I would quit while I'm behind right now unless you got a lot of money with you right now. Okay? I don't really want to hear it. I don't want to hear it. Tell it to some other judge in some other city in some other state. Where does she work?
Director
Got a problem.
makes $500.
She missed April 14th to 22, May 12th to 22. Came in October 12th, or was brought in, I believe. She was given, or at least it was on Zoom, given another date, January 3, 23. She didn't show up then. She was show caused again in June of 23. She didn't show up then. Wow. And that's just one file. That's just one of the files. I don't feel the need to go through the rest of these. All right, Heather, how much does she owe on all of these? On 224B and, I'm sorry, on 824B and 824 322A and 322B. I'll set those together.
322A has a balance of 411. 322B has a balance of 248. And then 824B has a balance of 306.
All right, I've got these a little bit mixed up here. I got 824B that has a balance of 306, true?
Yes.
All right. I've got 22F, 237, 322A that has a balance of
411 on that one.
411. She only had 3 files or she had 4? She has 4, doesn't she?
4 altogether.
Yeah, I don't know what I did with the other one. Hang on a second. Oh, no, I see. And what does she owe on 322B?
248.
Where has she been? Is there any valid excuse whatsoever?
I don't know, but she moved to a, in 2022, but she came back to me.
Forgot about the meters. Okay. I got it.
He does inform that other than he tests, he has no other criminals. Given, put a, that on the file with updated assessment.
Okay. I'm sorry, Heather. 824A, she owes how much?
824A, that's the one that she hasn't been sentenced on yet.
Oh, that's right. So we're setting a pretrial on that.
Correct, Judge.
Nice. She zoomed in once, so she wants to make it sound like she lives so far away. She zoomed in. She doesn't need to come in here from Atlanta, but all right. I just want to make sure I got these right. She owes 306 and she has a pretrial on a suspend charge. She's missed multiple court dates. The likelihood of her appearing again is not very good. Judging from what I've seen here, it's nearly impossible to rely on. So on 322A, I'm setting, and that'll cover B as well, 600 cash or surety, 600 cash or surety on 824A. 322A and B are covered together. 824A and B are covered together. Pretrial will be tomorrow, January the 8th at 10 o'clock. You'll be in front of Judge Hessen. And that's it. So you're going to have to post $1,200 to secure your release. If you post that, great. If not, you'll be brought over. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Young lady, I don't know what they're thinking, but you need to stop doing this. You don't have the right to do this. Good luck to you. Thank you. J. Javon Maurice Yi Neely Bay, 25F243246A and B and C and 25F243946. Where's this gentleman at? Or J. Jawan Yi Neely. Any idea, John?
Just here.
Madison Molinari. Madison Gabrielle Molinari, 24W835562. Good morning, ma'am. Your name?
Madison Molinari.
All right. You didn't check in with the prosecutor yet, right?
No, I did not.
So this is a review hearing.
Neely's in the courtroom, you know.
Where's she at?
Ready.
Why didn't you come up here when I called your case?
You said my brother, you said Jay Juan. I'm Jemiah.
Well, I mean, I can't have you represent him. Hang on. Hang on. Okay, so on review hearings, John, we got to send them over to the prosecutor.
Yeah.
Is he in what? Is he at 249?
Yes.
Just get here.
Your Honor?
Yeah, real quick on this Molinari, it's just a review hearing. I'm going to ask you to take a look at this. We should have had this into you before. My apologies.
No worries.
Thank you. John has it. Thanks. Ma'am, you go meet with the prosecutor and then you'll come back in here, okay? I don't understand. Is Jay Jawan, are you Jay Jawan?
No, that's my brother.
Well, where's Jay Jawan? Are you here? You're not trying to represent him, are you?
No.
I have two names. I had that one and I had.
They must have pulled the wrong file. Here, where's Molinari? Give Molinari to Bill, will you?
Hang on, Bill. Hang on. Everybody sure? Sure.
We might have pulled the wrong file here, Heather.
Bill.
Well, this is Matthew. So that's Mr.
Judge,
So
we do have Jay Jawan under the 840s today, but we also have Janaya on too. We have a lot of G. Neely's on the docket today.
I see.
State denial.
Yeah, so these are not the right files. Charles Lester Laney, 25W39812.
Good morning, Judge. And as I get to come back from Mr. Neely. Ladies, I apologize. I got caught up with the whole thing.
I can't,
Mr. Lane, state your full name.
Charles.
I'm not gonna adjourn this again.
Your Honor, may counsel and I approach.
Your appearance-
Briefly,
your appearance-
William York County City, Whitby.
Why wasn't he here December 10th?
Judge, that was on me. There was confusion as to whether or not,
How was there confusion?
well, Judge, I was retained on this case way back in September. Originally, they had assigned Mr. Laney to my brother, who was also an attorney, Judge. And the notices were going to him.
Guys, I can't keep adjourning these.
This would be a last, may we approach, Judge?
It's 100 days old already.
I understand, Judge.
Judge?
Very quickly.
Judge, I haven't wanted him so.
Hang on a second.
Okay.
John, go off YouTube a sec, will you? Go off the record, please. 4898. Good morning, counsel.
Morning, Your Honor.
Your appearance,
James Jeremiah on behalf of Ms. Dan, P 60260, she's present by laughter.
ma'am, your name?
Lexi Dan.
So I want to make sure, my notes were not very clear here. It looks like, first of all, she was charged with 3 different counts. She had OWI occupant second, less than 16, which as you know is a 5-year fine. She also had 2 other counts, which were consisting of, let me just give me a second here. Which consisted of a charge of OWI second. That was set forth in count 2, which was also, it was actually a high BAC, OWI high BAC set forth in count 2. And then she also had a charge of operating while impaired second. As far as I can tell from my notes and everything here, she pled to OWI occupant less than 16, a 1 year. The felony count relating to the OWI occupant as well as the super drunk. And Heather, I want to make sure that everything is reflected accurately. I did not make very good notes on the register.
Beth did come down this morning and
Right.
speak with Lisa about it. So I believe everything should be correct in the system now.
Right, so I also had, but I want to be clear about this, so count one, there was a plea to, the lesser included of OWI occupant less than 16, a 1 year. Count two was super drunk, second, with the prior, which is also a felony, that they went ahead and dismissed. And then count three was operating while impaired, second, which they also dismissed, but a count was added of child abuse in the 4th degree. So I'm going to sentence, which is also a 1 year. So I'm going to sentence on the OWI occupant less than 16 and child abuse 4. I'm going to put it on our sobriety court register. As to OWI occupant less than 16, the terms are going to end up running concurrent. As to that charge and the child abuse 4th, and then all other charges will be dismissed. That being said, have you had a chance to review the report? Do you agree with all of that?
That's correct, Your Honor. Double check. Yes.
Yeah, I mean, I just, they did this on a little bit different form because it was sobriety court. And that's it. That's all I'll say about it. For the record, a victim's rights notice was sent to Mr. Hughes. I believe it's Mr. Hughes. Just give me a second. Yeah, Josiah Davis, care of Forrest Hughes. Is that individual here? That individual is not here. You can go ahead and proceed. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
We have reviewed the report. The stand has also reviewed the report. No objections or corrections.
All right. Anything you would like to say?
Very briefly, Your Honor, I sent, and I apologize, I just gave it to the court today, sort of a bullet point letter. And if the court doesn't have it, I have a copy I can give you right now.
I don't believe I've received that.
I will hand it to the court and I will summarize it very quickly.
Okay, you can hand it up. Thank you.
Because although the pre-sentence report's accurate, Your Honor, the question is, why does this keep happening to Ms. Dan? And I think that's what I kind of lay out very quickly in my letter. She was, I don't want to get into too many details of the report, but she was the victim of some abuse multiple times as a child. And her substance abuse stems not from her desire to party or have fun, but to deal with this trauma. Which will segue into, she's aware of that. She was taking some medication to curb her ability to drink. Then she got pregnant and had to go off it.
The Vivitrol.
Correct, Your Honor. She has, since her arrest on this, been working on her addiction. But I think more importantly, the underlying issues, going to mental health counseling, going to meetings, going to family counseling, going to individual counseling. Talking to her today, she says, every day she has some sort of meeting, some sort of therapy to go to. Recovery for her has been a full-time employment, really. One thing she wanted to do today, but she said she just couldn't do it, is read some letters to her children that she wrote. Those letters were both an apology for her actions, but also an explanation. And I think more than anything, what those did was help her understand the effects that her actions have on her children and how much they impact them. I've received calls and texts and support from her current boyfriend, who she has one child with, they're expecting her second one. He's committed to her sobriety and sober living. A very good friend who's been helpful in supporting her, giving her rides, making sure she gets where she needs to go. I think all these things show that she's really committed to her recovery. She appreciates, she's, I think, one of the few drunk driving clients I've had that doesn't complain about the tether, the alcohol tether. What she says is, thank God I have this on because I can't use the Vivitrol. It's really helping me stay sober. The court has the option of sentencing her to some jail time on the child abuse 4th. I think given the progress she's made in her recovery, I think that would be counterproductive. We're asking for a non-custodial sentence on that. If she doesn't continue to make these great efforts, the court can at that time, I think, impose a jail sentence. But I think as long as she's working so hard, I think the court needs to let her continue that.
Anything that you would like to say?
I'm pretty sure that the static saved me and my baby's life. So I just wanted to say thank you for that. I'm really happy that I got caught that day. I'm 85 days sober. I go to a meeting every day. I do everything that I'm supposed to do. And I want to help other women like me once I start getting through this program.
I'm sorry, I didn't hear that last sentence.
I just want to help other women like me once I start getting through this program.
Well, I'm troubled. I'm going to tell you my negative comments first. You know, one of the things, I've been sitting here quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility for our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids, kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. Now, I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, do you have a young child in your car? And that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes,
And the child that was in the car was how old?
it was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little, they don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read in. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. And I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one's boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate, and you're going to get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things, and they wanted me to send you to jail in so many ways. I'm going to read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. Jail condition may be waived at the discretion of the court if the defendant completes a specialty court program. Court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing. Really, it was an enhanced from super drunk, second, which makes it a felony, child occupant less than 16 with a prior, which makes it a felony. So there was no OWI 3, but they were enhanced and they were felonies. 2 years probation sentence agreement with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination. 33rd District program is acceptable. We think it's more than that. Full restitution, parenting responsibility should be included. Defendant fails out of the sobriety court or specialty court due to poor performance, commits another crime while on probation. The judge finds sufficient cause to terminate the balance of the year. 1 year must be served in jail. No work release or waiver. The above are recommendations only, is what I made them add. The court need not order 1 year in jail if the defendant does not successfully complete program. And I've gone round and round with them about that, because they're not the judge. And they have the right to do what they want to do and enter in sentence agreements, but I don't have to go along with sentence agreements. I thought that was overly harsh, especially for somebody that might struggle and get to the end and violate, and I'm not giving them a year. But I want there to be no misunderstanding. And I know I'm talking a lot because I'm troubled by this one. I want there to be no misunderstanding. You fall down on this, you're doing a year. Your lawyer has done a tremendous job for you. Did I let everybody finish? I'm ready to sentence if I did.
Yes, thank you.
Anything else?
No, yeah.
I'll get the count. I'm going to call it count 3. It should be child abuse. They're not adding a count. They're reducing a count from operating while impaired second, which is a 1 year, as far as I'm concerned, to child abuse 4th. 2 years probation. You cannot leave, but first of all, you have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, and you're not to go to any place that sells or dispenses or alcohol. And I'm talking as its primary source of business. I'm not going to consider it a violation if you go into 7-Eleven and buy a Diet Coke, but you're not to go to any bars. You're not to go to parties where alcohol or drugs are being consumed or dispensed. You're to submit the chemical testing, PBTs and ETGs on demand of probation. We're gonna pay for those tests as long as you go every single time, and as long as you test negative every single time. You test positive, you're gonna end up paying for the test and you're going to be incarcerated. You complete the recommending 60 days. I'm gonna make it 90 days on the sober link. I know you have a scram. We're gonna change the scram to a sober link. It's gonna be on our dime now with our grant. You fail the test, you test positive on a test, you're gonna not only be subject to sanctions, you're gonna be paying for your own testing for a lengthy period of time. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA sponsor. You're to attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. You are to attend and complete the Armed Specialty Court Weekend Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to meet with probation in the off week. You're to obtain and maintain employment with proof provided to the probation department. And this is all on count 1. This is all for the OWI occupant. Less than 16, 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So that is 5 1/4. Your screening fee is 60 for 585. You have probation fees of 480, bringing your total to 1,065. You have sobriety court fees of 360, bringing your total to $1,425. Now, I'm going to order that you serve 11 days jail, credit 1. Actually, I'm going to order 15 days jail, credit 1 for 14. I'm going to allow you graciously to serve 10 of those days on the court work program. There is a $35 a day charge for that. You're going to serve the other 4 days by way of community service. You're going to serve 4 days of community service. I'm going to give you time to complete that, and that won't be, I'll give you all the way until May the 31st. You're going to have your hands full. You're to complete 10 days on the court work program and pay a sum of $35 for each day ordered. I'm going to make a note that that is $350 plus your $1,425. So your total here amounts to $1,775. Now, I'm going to talk about court work program fees in a second. All right. Now, if you violate, your probation could be revoked. You could be incarcerated for a year with credit for 1 day served, and any other time you serve on the court work program, community service. Defendant not to be completing court work. You're 5.5 months?
7 months.
7 months, I'm sorry. Not to be completing court work not to be completing or starting court work program until at least 3 months after child born. Your community service, I think you're going to be able to do one way or the other by May the 31. That's not taxing, and I'm not going to have you start on a court work program now. As to count child abuse, I'm simply going to indicate I'm putting you on the sobriety court for that as well. Sobriety court terms and conditions concurrent. This is on, and I want to make sure it's mentioned there, other sobriety court terms and conditions set forth in count 1 to run concurrent. So I'm basically ordering everything on this case that I just ordered on the other one. However, I am going to add a little bit of fines, but not much. Heather, I don't remember. Can you ask Amy? There's one of these, when it's a state case, we don't charge the victim's rights or justice assessment. I can't remember if I charge the 75 or the 50, but not both. So can you check with her if you don't know the answer, or Lisa, please? I'm going to simply go. So I'm not charging any other fees except to say 100 fines, 100 costs, and then you paid the screening fee. You're going to pay everything else, and I will either charge you 75 for the victim's rights or $50 justice assessment. So your total there is either going to be 275.
I'm checking right now.
take your time, or 250. Again, if you violate, your probation could be revoked. You could be incarcerated for a period of 365 days with 1 day credit. Now, I just want to double check one other thing. They ran Forrest Hughes is who? Your boyfriend?
No, he's a friend of mine. He's just a friend. He just helps me out with rides and getting me.
Well, why did we send the victims' rights? He's not the father of any of the children, is he?
No, we were unsure as well. That's why he didn't have anything to say. He didn't know what to say or what to do. And when he called, he couldn't get a hold of anybody around.
All right.
Okay, Judge,
Yeah,
we charge the 50.
so it's $50, something. So it's the $50 judgment fee, justice assessment fee for a total of $250. So you owe $250 plus you owe on this case, and I can't do much better than this $1,775. So you owe $2,025. Now, I'm going to let you pay this case, the child abuse. I'm just going to give you a date of May the 1st. Can you do it by then? That's only $250.
I can do that, Your Honor.
And then I'm going to have you pay, and you can tell me if you can do this. But I need you to stick with it. $50 a week starting May the 8th.
I need you to say that again. I'm sorry.
50 per week beginning May the 8th. Can you do that?
Yes.
Pay 50 per week on count one beginning May the 8th. And if you ever need more time, you need to come talk to me. All amounts due by November 1 of 27. Okay? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm not taking action on the immobilization since you didn't own the car. There's no evidence that the car owner allowed you to operate while knowing you were intoxicated, and that's what I'm going to do. You'll go meet with probation. We're going to switch out the scram. The judge said switch out the scram for sober link, and we're going to have to send a letter to the county because that's where she got it at. Heather, she got the scram tether at the county when the bond was set. Okay.
Okay, Judge.
All right. Thank you very much. Good luck.
Thank you.
Have a good day. Nice day to your counsel.
Thank you, guys. Appreciate it.
Curtis Brett Hamadi, 26R70167. Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, so this is Judge Hessen's case. She's not here. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So you got it.
I do, Your Honor.
Go ahead.
Your Honor, December 12th, 2025 at approximately 7:08 a.m., officers Christopher LaFleur and Stephen Corn, both with the Rockwood Police Department, was dispatched to the Rebel gas station 22855 Huron River Drive within the city of Rockwood for a panic alarm. Upon arrival, the officers met the cashier identified as Philip Morales. Philip advised that one of his regular customers by the name of Curtis Hamady had come in the store a couple days prior, and when he walked in the store, Philip asked him if him, who was with his girlfriend, asked him if he was ready for the upcoming holidays. The girlfriend replied, "Ho, ho, ho." Philip then told Curtis's girlfriend that she can do whatever she wants in her free time. This comment made Curtis upset, but he immediately left the gas station without incident. On 12/12/25, Curtis came in the gas station, bought 2 large cups of coffee, and as he approached the counter, he got in an argument with Philip over the comment he made about the ho, ho, ho. As the argument escalated, Curtis grabbed the 2 cups of coffee and threw them on Philip, causing coffee to go all over him as well as the store. Philip then at that point said he was going to call the police and hit the panic button. Curtis left the store. Officer Korn reviewed the store video, and it did show that Curtis, who Officer Korn had arrested prior months ago, could identify him as our subject, Curtis Hamady. On 12/12/25 at approximately 8:25 a.m., Curtis Hamady called the Chief Krause of the Rockwood Police Department on a recorded phone line and admitted to the incident at the Rebel gas station. Curtis told the chief that he said he pushed coffee cups that did contain hot coffee towards the rebel employee. I sent a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
Based on your sworn testimony, I find the crimes of assault and battery and disturbed the peace were committed. There's probable cause to believe the crimes were committed by the defendant and authorize the issuance of the complaint warrant, $200 bond. Maybe you can call them and tell them to come in the warrants, if Mr. Hamadi, I'm saying, and just tell him the warrant's going to remain in effect unless and until he does. And I'm signing the complaint and we'll put it in the lien. Okay?
He's on probation through the court also, so.
Okay, thanks.
All right.
By the way, I'm changing the date. You sent it over the other day, the 3rd or what have you, and so I'm changing the date on there to the 7th.
Okay, thank you, Your Honor.
Happy New Year, Lieutenant. Have a good day.
Thanks, you do the same.
Harms K. Canoon, 25W840939.
Morning, Your Honor. Paul Yoetz on behalf of Mr.
What started as a routine sentencing hearing quickly became an emotional courtroom moment nobody expected. A mother stood before the judge after pleading guilty to driving under the influence while a 2-year-old child was in the vehicle. Even more shocking, she was pregnant at the time. As the judge reviewed the case, he became increasingly troubled by the choices that had placed multiple children in danger. Looking directly at the defendant, he delivered a statement that instantly changed the atmosphere inside the courtroom. On its face, your child had no chance. He explained that children depend on their parents for protection, guidance, and stability, and that drugs, alcohol, and reckless decisions can rob them of opportunities before they even have a chance to grow up. The judge spoke passionately about the responsibility that comes with being a parent and said he was deeply disturbed by the behavior described in the case. But then the hearing took an unexpected turn. Despite his harsh criticism, the judge acknowledged that the defendant had made significant progress since her arrest. She had remained sober for 85 days, attended recovery meetings every day, participated in counseling, and committed herself to rebuilding her life. Because of that effort, the judge decided to give her an opportunity through sobriety court instead of immediately sending her to jail. However, his warning was unmistakable. If she failed the program, violated probation, or returned to her old habits, she would spend an entire year behind bars. The judge made it clear there would be no excuses.